The subject of my talk is the principle of the general welfare in the United States Constitution. When people talk about that principle, they usually are referring to what's known as the General Welfare Clause in Article 1, Section 8, Clause 1. Now, actually, this is a mistake because the principle of the general welfare is not localized in that clause, but really pervades the Constitution. Nevertheless, that clause is a good place to start learning about the subject matter. Article 1, Section 8, Clause 1 provides, "The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States." Now, on its face, this clause simply empowers Congress to lay and collect taxes with certain limitations, namely, as pertinent here, taxes must be imposed only for three purposes: to pay the debts of the United States, to provide for the common defense of the United States, and to provide for the general welfare of the United States. That is, the words "to pay the debts and provide for the common defense and general welfare" do not grant powers to Congress in addition to the power to lay and collect taxes, but instead they define and confine that power. And probably within that phraseology, the most important words are common and general. Whatever Congress lays and collects taxes for, the ultimate purpose must meet some test of universality. Now, it just so happens that Clause 1 is not the only clause in Article 1, Section 8, which sets out specific limitations to a delegated power without generating new powers from those words of limitation. You look at Article 1, Section 8, Clause 15, which empowers Congress to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. This plainly means that Congress may provide for calling forth the militia for those three purposes and no other purpose. And no one has ever claimed that per force of the language Congress may call forth the militia to execute the laws of the Union, that somehow Congress has the power itself to execute the laws of the Union, other than through the militia. In fact, the Constitution says exactly the opposite, because it explicitly delegates to the President of the United States the duty to take care that the laws be faithfully executed. So on this kind of an obvious and straightforward reading of the Constitution, which is perfectly consistent with different provisions of it, Article 1, Section 8, Clause 1 grants no separate, independent, general powers to Congress to pay debts, to provide for the common defense, or to provide for the general welfare. Now, of course, because Congress has power to lay and collect taxes for those purposes, necessarily Congress must have some powers somewhere to pay debts, to provide for the common defense, and to provide for the general welfare in ways that may require expenditures of tax receipts. But the powers that address those matters have to be found outside of Article 1, Section 8, Clause 1. And because they can be found elsewhere, there is no need or justification to derive them from some kind of forced or twisted reading of that clause. For example, per force of Article 1, Section 8, Clause 1, Congress shall have power to lay and collect taxes to pay the debts of the United States. And the powers to incur and to recognize and to pay debts are found in Article 1, Section 8, Clause 2, to borrow money on the credit of the United States, and Article 1, Section 8, Clause 18, to make all laws which shall be necessary and proper for carrying into execution all powers vested by this Constitution in the government of the United States. So, no general open-ended power to pay debts has to be derived from Article 1, Section 8, Clause 1, and therefore no such power should be derived from it. Similarly, per force of Clause 1, Congress shall have power to lay and collect taxes to provide for the common defense of the United States. And very extensive powers exist to provide for the common defense. Article 1, Section 8, Clauses 10 through 18, Article 2, Section 2, Clause 1, Article 4, Section 4. Therefore, no general open-ended power to provide for the common defense has to be derived from Clause 1, and no general power ought to be. Finally, per force of Article 1, Section 8, Clause 1, Congress shall have power to lay and collect taxes to provide for the general welfare of the United States, and the powers to provide for the general welfare are found among all of the remaining powers that the Constitution delegates. Therefore, no general open-ended power to provide for the general welfare has to be derived from Clause 1, nor should it be. All right, this all seems very straightforward and literal, if you will, which is the correct way of interpreting the Constitution. Nonetheless, the General Welfare Clause has been construed essentially in the opposite fashion by the Supreme Court of the United States, as if that clause contained four powers. The power that it does contain, the power to lay and collect taxes, and then a power to pay debts, a power to provide for the common defense, and a power to provide for the general welfare. This came about really only in the mid-1930s, decision of the United States Supreme Court, United States versus Butler, which held that Congress may spend for the general welfare as defined by Congress, and that this supposed authority is in no way limited to Congress's exercise of any other powers enumerated in Article 1, Section 8. Now, that kind of reasoning really raises more questions than it answers. And the very next year, a case called Helvering versus Davis, the court said, the concept of welfare or the opposite is shaped by Congress. Well, if that's true, is the concept general also shaped by Congress? No reason is apparent why one rule of construction should apply to the word welfare, but another rule of construction should apply to the word general when they're both in the same phrase and the latter modifies the former. But if both welfare and general are to be shaped by Congress, why are those words included in the Constitution at all? What purpose do they serve if Congress may determine for itself what they mean? If those words may mean anything at all, they must mean nothing in particular. So why does the Constitution not simply read that Congress shall have the power to spend at its discretion, or simply to spend? All right? We can't answer that question on the interpretation the Supreme Court has given us. Secondly, if Article 1, Section 8, Clause 1 can be construed to extend to Congress an unlimited power to spend for the general welfare, must it not also be construed to extend to Congress an unlimited power to spend to provide for the common defense? Indeed, the answer must be yes, because the two nouns are both objects of the same verbal phrase, and they're linked by the conjunctive and, to provide for the common defense and general welfare of the United States. But if Clause 1 can be so construed, then why did the framers bother to provide in Article 1, Section 8, Clause 12, the power to raise and support armies, but no appropriation of money for that use shall be longer than a term of 2 years? And in Article 1, Section 8, Clause 13, the power to provide and maintain a navy. Moreover, under a power in Article 1, Section 8, Clause 1 to provide for the common defense that is unlimited, in the way the Supreme Court interprets the power to provide for the general welfare, may Congress raise and support armies for durations beyond 2 years, such as by raising some permanent tax for army appropriations? If not, why not? And if it can do that, then what happens to the maxim of construction that all fundamental constitutional principles are of equal dignity and must be enforced so as not to nullify or substantially impair the other? Why would the Founding Fathers have given Congress the power to provide unlimited funds for the common defense, but then said that no appropriation of money for that use shall be for a term longer than 2 years? Well, none of this makes much sense, so we have to revert to some more fundamental principles in the Constitution. And I call that principle the other general welfare clause, about which next to nothing is said in discussions about the general welfare. That clause appears in the preamble to the Constitution. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Now, this is actually the primary general welfare clause because it controls interpretation of the rest of the Constitution. According to the principles of statutory construction, which were applied in the late 1700s, a preamble, a statement at the beginning of a statute, would have precisely that effect. And the Supreme Court in Gibbons versus Ogden, as early as 1824, recognized that. The court said, if from the imperfections of human language there should be serious doubts respecting the extent of any given power, the objects for which it was given, especially when those objects are expressed in the instrument itself, should have great influence in the construction. All right, so according to that principle, the preamble itself would limit the power to lay and collect taxes, even if that power had not been explicitly qualified in its own clause by the language to pay the debts and provide for the common defense and general welfare of the United States. For the preamble teaches that we the people did not ordain and establish this Constitution for any purposes of defense and welfare other than the common defense and the general welfare. and self-evidently to require that the United States actually pay their debts with their own resources, in this case derived from taxes, is part and parcel of establishing justice. So you can take the words out of Clause 1 entirely, and it's all derived, or all the limitations would be derived from the preamble. So why are the words there in Clause 1 at all? Well, they must have been added to that clause by way of further prevision and precaution. That is, as a form of emphasis, to negate and preclude any possible misconstruction of the Constitution that would license the levying of taxes for defense or welfare of either just one or a few states, or of the special interests that the Founding Fathers called factions and were so worried about, or that would countenance any levying of tax money that would somehow be immune from the just claim of the United States creditors. So once again, all these words must be read as specific limitations on the power to tax, not as creations or expansion of some other powers. Well, that brings us to a more fundamental question. What might be the reason for this misconstruction of the General Welfare Clause that the Supreme Court has more or less foisted off on the country? Why, if the clause is so literally obvious in its meaning, has it been so badly construed? And for an explanation to that, we really have to turn, or I like to turn, to poetry. John Dryden, The Hind and the Panther, poem of his in 1687, one of the lines is, "No written laws can be so plain, so pure, but wit may gloss and malice may obscure." That's deriving principle. And then I turn to a modern principle, what I call criminal politics, that governmental control over private property through redistribution of wealth by taxation and spending translates into control of everything else. The answer here, then, is that misconstruction of the General Welfare Clause is one of the several roads, and probably the most important road, that criminal politicians have taken on their way to amassing totalitarian power for themselves. Not only does the Supreme Court's misconstruction of Article 1, Section 8, Clause 1 license Congress to spend tax receipts on anything that Congress deems to be the general welfare, but also, according to the Supreme Court, it licenses Congress to regulate anything on which Congress chooses to spend tax receipts. And there's the key link: spending and control. This concept is encapsulated most notoriously in the Supreme Court's 1942 decision, Wickard versus Filburn, where the court said, "It is hardly lack of due process for the government to regulate that which it subsidizes." So we have even more recently, according to the Supreme Court, South Dakota versus Dole case, 1987, the idea that by attaching conditions to the expenditure of so-called federal funds, that is, tax money of the general government, that Congress may exercise powers that are otherwise not delegated to it at all by the Constitution. The court says, "The power of Congress to authorize expenditure of public monies for public purposes is not limited by the direct grants of legislative power found in the Constitution. Thus, objectives not thought to be within Article 1's enumerated legislative fields may nevertheless be attained through the use of the spending power and the conditional grant of federal funds." That is, according to the Supreme Court, all by itself, the General Welfare Clause negates or renders redundant and unnecessary the enumeration of all the other powers in the Constitution, as well as conferring on Congress an unlimited array of powers that are concededly not delegated by the Constitution at all. It's a fabulous doctrine because it's totally open-ended. Logically, too, this theory would apply not only where Congress gives tax money to willing recipients, but in any case at all. So Congress could require unwilling recipients whom it wished to make the targets of otherwise unconstitutional regulations to accept grants of public money. And that would be the occasion and the excuse to impose those unconstitutional controls on such people. And I would ask the question, if not, why not? What's the limit? Right? Well, according to the Supreme Court, why not has no answer, because the supposed power of Congress to spend for the general welfare is essentially unlimited by any kind of judicial review. Again, the Supreme Court in South Dakota versus Dole, 1987, in considering whether a particular expenditure is intended to serve general public purposes, courts should defer substantially to the judgment of Congress. The level of deference to the congressional decision is such that the court has questioned whether general welfare is a judicially enforceable restriction at all. Well, if it is not a judicially enforceable restriction, then no American has a right to demand that it be exercised in a constitutional fashion, by definition. All right? So that's where it's left us. The Supreme Court has decreed that the General Welfare Clause has whatever meaning Congress decides to give it, and that meaning can rationalize the exercise of almost any power Congress desires to exercise, and to which Congress desires to attach conditions to grants of those monies. Well now, because Congress can absorb the entire income of every private individual and every private entity under color of the 16th Amendment, or at least claims that it can siphon unlimited wealth to itself through monetization of public debt by the Federal Reserve System, or emission of legal tender currency through the Treasury, which it claims it can do, and then can redistribute that take in any way it likes to willing or unwilling recipients with whatever conditions it chooses, which the Supreme Court tells us it can do, it follows that Congress can employ its supposed taxing and spending powers all by themselves to create a totalitarian state. Well, what then is the purpose or the worth of the rest of the Constitution? Except to set up a set of procedures by which people can be elected and by which legislation can be enacted, through which this totalitarianism can be imposed on the rest of us. That's another question that the Supreme Court can't answer for us. Well, what's the underlying cause of all of this? I consider it to be the antagonistic relationship between the concept of general welfare and factionalism. Now, to a certain extent, at least one of the founding fathers is somewhat responsible for this problem. We really have to recognize that a very dangerous fallacy lurks in James Madison's theory of the extended republic, the theory that Madison put forward as a basis for securing America's freedom against encroachment from unlimited government. If you remember in the Federalist number 10, Madison observed that among the numerous advantages promised by a well-constructed union, none deserves to be more accurately developed than its tendency to break and control the violence of faction. The friend of popular governments never finds himself so much alarmed for their character and fate as when he contemplates their propensity to this dangerous vice. Now, Madison defined a faction as a number of citizens who are united and actuated by some common impulse of passion or of interest, adverse to the rights of other citizens or to the permanent and aggregate interests of the community. That is, factionalism by definition is antagonistic to the general welfare. Now, Madison also recognized that the latent causes of faction are sown in the nature of man, and then the most common and durable source of faction has been the various and unequal distribution of property. Those who hold and those who are without property have ever formed distinct interests in society. That is, the primary motivation for factionalism is greed, and the goal of factionalism is redistribution of wealth. Madison further pointed out that the regulation of these various and interfering interests forms the principal task of modern legislation and involves the spirit of party and faction in the necessary and ordinary operations of government. No man is allowed to be a judge in his own cause because his interest would certainly bias his judgment and corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judges and parties at the same time. Yet what are many of the most important acts of legislation but so many judicial determinations, not indeed concerning the rights of single persons, but concerning the rights of large bodies of citizens? And what are the different classes of legislators, but advocates and parties to the causes which they determine? It is vain to say that enlightened statesmen will be able to adjust these clashing interests and render them all subservient to the public good. Enlightened statesmen will not always be at the helm. And don't we know that? It's certainly been proven true. So Madison concluded the causes of faction cannot be removed, and relief is only to be sought in the means of controlling its effects. And he had a twofold solution. First, he proposed what he called a republic, which he described as a government in which the scheme of representation takes place. That is, it's controlled by the people through the voting process. Second, and perhaps more important, he advocated an extended republic. As he explained, extend the sphere of society, and you take in a greater variety of parties and interests. You make it less probable that a majority of the whole will have a common motive to invade the rights of other citizens. Or if such a common motive exists, it will be more difficult for all who feel it to discover their own strength and to act in unison with each other. The influence of factious leaders may kindle a flame within their particular states, which will be unable to spread a general conflagration through the other states. A rage for paper money or for any other improper and wicked project will be less apt to pervade the whole body of the Union than a particular member of it. So if you look at the base of this theory, the foundation, Madison is saying that the general welfare will somehow arise out of political and legislative struggles among self-interested factions eager to obtain their own special interests at the expense of everyone else, as long as no one faction or group of mutually cooperating factions can form a legislative majority. All right? That's the trick in his theory. Now, this theory could be described in several ways. It could be called government by the invisible hand of laissez-faire competition in the political marketplace. The idea being that free competition and factionalism will prevent any faction from obtaining monopoly power. Or it could be called political anti-Darwinism, the idea that the strongest predators need not always prevail, but can be held in check by the weaker ones. Or it could be called political alchemy, the idea that political vice can be transmuted into political virtue and selfishness into altruism, or special interests into the public good. But I think that no matter how it is described, in principle the theory is incoherent, because its fundamental premise is that good government will arise from the self-interested aspirations and conflicting political interactions of bad people, or that conflict will engender harmony. Also, the theory isn't plausible. If all of the selfish actions of various factions cancel each other out so that nothing bad occurs, then most likely nothing at all will happen either. It may be considered good that nothing bad happens, but it will hardly be considered satisfactory that nothing else of any good comes from the process. What's the point of having a government at all if the only outcome of all of its expensive operations is to accomplish essentially nothing? Simply to stymie all of these conflicting interests. On the other hand, if some factions do finally prevail over the others, then by definition, bad government will result, because no faction concerns itself with the general welfare, only with its own individual private interests, no matter the cost to the general welfare. Furthermore, the more that some factions prevail, and are seen to prevail, and are understood to prevail precisely because they're operating as factions, the more other people will recognize the advantage or the necessity of organizing themselves into competing factions to proceed on the very same principle and to the very same ends, and the worse the government will become. Factionalism being by definition a form of personal, group, political, and eventually legal corruption, once factionalism becomes near universal, the political system, the law, and then society as a whole must ultimately collapse. The cancer destroys the vital organs, and the body dies. So Madison's theory really provides no basis for concluding that the political or legislative victory of any one faction or group of factions interested in its own special welfare will produce the general welfare, let alone that a society totally organized and operating on the principle of unlimited factionalism could ever arrive at the general welfare as the consequence of a government of that nature. Indeed, Madison's theory does not even begin to explain how factionalism could bring about the general welfare. All he suggests is that in an extended republic, again quoting him, a rage for paper money or any other improper and wicked project will be less apt to pervade the whole body of the Union than a particular member of it. That is, in such a republic, factionalism will be less dangerous than in other forms of popular government, but nonetheless not necessarily without danger, and perhaps without fatal danger. For even in an extended republic, factionalism will not bring about the general welfare unless it is in the interest of at least one of the strong factions to promote the general welfare rather than its own special interest, in which case the faction will not be a faction at all by definition. So that the theory, if it's going to function in a predictably positive fashion, has to contradict itself by hypothesis. Now, it's still not a worthless theory, because properly applied, it does explain quite adequately why this country has been perennially saddled with a government that goes from bad to worse. By hypothesis, factions have no interest in good government or in limited government. They are interested in effective government. That is, government that gives them what they want. Right? That necessarily means a powerful government, a government capable of making these decisions and taking such actions. And because any particular faction may want the government to do just about anything for it at any particular time, that means a government with powers that tend towards totalitarianism, by hypothesis. Secondly, factions have no interest in the long-run freedom, prosperity, or stability of society. Factions want a result favorable to themselves now. To obtain that result, every faction will press Congress to adopt and the Supreme Court to read into the Constitution whatever theory of governmental power works now, no matter how dangerous it may be to the whole country in the future. Factions are composed of essentially unprincipled, short-term pragmatists. They don't necessarily think consistently or even at all about the long-term consequences of their actions. They simply grab for whatever power they can seize at the moment for the principles and purposes immediately at hand on the basis of Keynes' famous principle, in the long run we are all dead. All right? And what happens after we're dead, we don't care about. But in doing so, especially through judicial activism, they really sow dragon's teeth. Now here I must raise another principle, which I call the Korematsu Principle. This comes from a passage in a dissenting opinion by Justice Jackson in Korematsu versus United States, which was the Japanese concentration camp case. And the court upheld the power of Roosevelt administration to put Japanese Americans in concentration camps during the war. Jackson dissented, and he said, once a judicial opinion rationalizes a governmental act to show that it conforms to the Constitution, or rather rationalizes the Constitution to show that the Constitution sanctions such an act, the court for all time has validated the principle. The principle then lies around like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need. Every repetition embeds the principle more deeply in our law and thinking and expands it to new purposes. All who observe the work of courts are familiar with the tendency of a principle to expand itself to the limit of its logic. If we review and approve, a passing incident becomes the doctrine of the Constitution. There it has a generative power of its own, and all that it creates will be in its image. Now, on the basis of the Korematsu Principle, any judicial doctrine that is favorable to a particular faction will be used, no matter how unconstitutional or even anti-constitutional. And if it's expedient for the faction to promote it, it will be expanded to the limit of its logic by that faction and by other factions who want to extend governmental power so they can get what they want now. And so the process goes on and on and on, feeding on itself, right, accelerating through its own internal logic, because there are no or very, very few factions that will ever push for principled permanent restrictions on governmental power. They are only interested in expedient uses and expansions of governmental power. Now, this is because factions generally fight among themselves over specific applications of power that might favor one faction and disfavor another faction, but usually they do not fight over the existence of the power itself, let alone over the principle that government should have only strictly defined and limited powers. So the conclusion to which I come is that Madison's theory works only in one direction, to the inevitable dissolution of good government and the exacerbation of bad government. And it does so for three primary reasons. Number one, it is not true that simply because there may be many factions with different and conflicting interests, that factionalism cannot prevail politically, legislatively, and especially judicially.